There are two types of potential claims that Rosa has. Firstly, I will discuss Tate Modern's potential liability concerning Rosa's illness. To do this, I will first explore the causative issues in terms of Rosa's initial exposure to atrium, while looking at the operation of legal and factual causation. I will also look at the potential defense of contributory negligence as well as the formalities pertaining to the intervening act which may break the causative link. The second claim pertains to the role of Dr. Khan's wrongful diagnosis and his potential liability. I will explore whether there has been a breach of duty of care and to what degree is Dr. Khan responsible for the harm Rosa is suffering regarding her diminished survival rate. There are three elements Rosa must satisfy to prove Tate Modern's liability. First, there must be a duty of care. Given that there is an employer-employee relationship, this is already established in line with Fairchild and Glenhaven funeral services. Therefore, Tate Modern is responsible for working conditions, particularly the exposures Rosa is subjected to. Is there a breach in this duty? Yes, due to Rosa's exposure to the atrium alone. Lastly, causation. This is the source of contention, as Rosa must establish a causative link. Rosa must prove both legal and factual causation to succeed in her claim. For factual causation, it must be established that but for the exposure of atrium that Rosa suffered whilst working for Tate Modern, she would have suffered no harm. This test is established through Barnett and Chelsea. However, this is not the case here for two reasons. One, given that Rosa was exposed to atrium from multiple sources, and two, it can't be established on scientific evidence if atrium is a divisible or an indivisible harm. Yet we can go further in establishing liability beyond the but-for test. There are two types of arguments to be made. The first is where Rosa's harm was as a result of a cumulative exposure to atrium. The court could still impose liability. The understanding from Bonington Castings Limited and Wardlaw puts the burden of proof on Rosa to show that the exposure suffered at Tate Modern materially contributed to the harm she suffered. On the balance of probabilities, Rosa experienced a more consistent and prolonged exposure at Tate Modern than any other source, meaning that they materially contributed to the harm and are therefore liable, according to Bonington. However, between the period of 2010 and 2012, Rosa was exposed to atrium whilst volunteering at several churches. Ordinarily, this results in liability being apportioned severally. This requires the churches to be held responsible for the exposure she experienced there. If the harm was indivisible, caused by a singular exposure, the issue becomes a bit more complex. This would mean there are multiple causative agents requiring a single exposure causing an indivisible injury. The case of McGee and National Coal Board develops the law in Bonington, as it establishes that to impose liability, a breach of duty must materially increase the risk of the harm she suffered. For this purpose, the 5 years of exposure Rosa experienced at Tate Modern is sufficient to constitute a material increase in risk. However, if atrium is an indivisible harm, this produces several and joint liability on the part of Tate Modern and the churches Rosa volunteered at. Therefore, both defendants would be liable for the whole of the harm. This allows the claimants to go after any of the defendants for the payment of compensation. Yet, it would be a far more benefit for Rosa to go after Tate Modern rather than the churches. The courts are likely to apply policy consideration to protect the church, in that the courts may view the church as a charitable organization, and simply there would be less chance they can afford the compensation as well. Regarding legal causation, Rosa must demonstrate that the injury was not too remote a consequence from the defendant's negligence. This is a matter of establishing the foreseeability of harm. In Hughes and Lord Advocate, the House of Lords states that only the type of harm and not the extent of the harm needs to be foreseeable. This is a question of interpretation for the courts then. Knowledge in the medical community of the effect of atrium may negate the fact that they did not foresee Rosa's resulting disease. Therefore, it would likely satisfy the foreseeability element. Yet, Tate Modern may put forward some defenses, the most significant one being the defense of contributory negligence. Rosa's use of Atrium on her own personal projects may have contributed to the harm that she suffered. If the courts determine exposure to Atrium to be an indivisible harm, Rosa's self-exposure would, however, not defeat the principle of material contribution to to risk that imposes liability on Tate Modern in the first place. The courts would likely apply the consideration, as in Reeves and Commissioner of Police, by prioritizing the duty of care that was broken in the first place. On consideration of the balance of probabilities, and in accordance to the Section 1.1 of the Contributory Negligence Act, they may reduce compensation by the extent to which Rosas materially increased the risk of a harm by considering the length and the intensity of a self-exposure. However, it's if the exposure to Atrium is said to have cumulatively caused the harm, the courts will likely apply similar reasoning as in Fitzgerald and Lane. First, liability would be imposed to the extent to which all parties contributed to the whole harm, reducing compensation to the degree in which Rosa contributed to the harm on herself. It is important to note, if liability cannot be imposed on Dr. Khan for the further harm done to Rosa, according to Robinson and the Post Office, the chain of causation is not broken, meaning Tate Modern is liable for the harm done to the extent which they were made worse by Dr. Khan. I will now go on to talk about Rosa's claim against Dr. Khan. In establishing causation, it is asked if the Negligence Act significantly altered the chances of the claimant's survival. In the case of Gregg and Scott, the law lords made it a requirement for the claimant to show that the negligence of the doctor made it more than 50% more likely that the patient could not be cured. Had the diagnosis been done correctly, Rosa would have had a 45 to 55% chance of survival. The uncertainty of her chance of survival confuses the conclusion as to causation. Rosa must establish that but for the negligence, she would possess the required chance of survival. However, given that her chance of survival might be below 50%, as well as the likely fear of a floodgate of cases in which patients may successfully prove causation despite an inconclusive chance of survival, the chances of successfully establishing causation in this case are quite low. To establish a breach of duty of care in the case of medical negligence, there is emphasis on reasonableness pertaining to the actions of a reasonable professional. Justice McNair, in the Bonham case, establishes the requirements that if a doctor is acting in accordance with a practice accepted by a responsible body of medical men who possess similar skill, his actions cannot then be held as negligent. Whilst we must ask whether Dr. Khan's diagnosis of asthma constitutes a standard of practice accepted by a responsible body of doctors, Lord Denning in Whitehouse and Jordan, however, suggests that some errors, though accepted, are too glaring to not constitute negligence. For these reasons, the considerations in Bolito and City and Hackney are vital. It is not enough that a medical body might agree with Dr. Khan's actions. The court also has to ask if Dr. Khan's opinions withstand logical analysis. Therefore, the fact that Rosa is dealing with a rare cancer of which there is limited knowledge as to its development may expand the definition of reasonableness in this particular case. Furthermore, the wheezing and difficulty breathing experienced by Rosa may appear to be seemingly ordinary symptoms. Therefore, Dr. Khan's diagnosis might seem reasonable and logical in the court's view. It is therefore unlikely that the court will conclude that Dr. Khan's actions has breached a duty of care. Rosa is likely to be successful in the claim against Tate Modern, both from a legal and a factual causation perspective, despite her volunteering with the churches confounding the claim. Furthermore, Tate Modern are likely to be liable for the extent to which Dr. Khan made Rosa's harm worse. Yet, Dr. Khan himself may not be held liable for the reduction of Rosa's chances of survival, significantly due to the rarity of the type of cancer Rosa is dealing with. In imposing liability on Tate Modern and absolving Dr. Khan of further liability, Rosa's claim exemplifies why and how policy decisions are entrenched in the operation of law in the field of negligence, specifically because policy works to assist the law of tort in achieving its aims despite absence or uncertainty of key facts.